Good afternoon, students. In the continuance of the previous lecture, we are going to study further the rules of interpretation of Constitution. Now, coming to the first rule of interpretation for Constitution we are going to discuss today is principle of incident and ancillary powers. As we discussed in the previous lecture, it is of the similar concept as we discussed under principle of implied powers. The only difference between this rule and the previous rule, the principle of implied power, is that it generates incidental and ancillary powers, whereby ancillary and incidental powers are incidental powers which come to you on a particular happening or a not happening of a particular sentence or a action, whereby ancillary powers can be powers which are arising out of certain powers which have been already given to a person or a official authority. Now, the very good one example under this principle is, now for example, if any authority under the Indian laws is provided with a law to impose tax on somebody, or probably for example, a landlord is given the power to ask for a rent because he is renting you his property. Similarly, the landlord is also given a power to invade your to remit your rent. He can by himself on his own discretion say remit your rent as to whatever limit, or even probably cancel it for that matter. Similarly, an authority which is allowed to impose taxes on a particular person or the people or the citizen of India have the power to keep a check and balance on the evasions of taxes and modify the budget and modify the revenue laws and financial laws accordingly as per the need, how they feel should be done. Now, coming to the second principle is principle of implied prohibition. Now, principle of implied prohibition means it originates from a Latin maxim, expressio unis e exclusio alteris. This particular maxim can be translated as express mention of a particular thing. Express mention of a particular thing will automatically lead to an exclusion of another. Now, example under this particular principle is, now for example, we've all studied section schedule 7 of under the Indian Constitution Act. We are very well aware of the 3 lists which are mentioned under schedule 7. Now, what these lists constitute of? These particular lists, which are namely state, union and concurrent list, describe you or give you an particular subject area or a broader headed area whereby the state legislature, union legislature and both of them together are divided, the powers are divided, the areas under which they can legislate and make laws is segregated. This is what implied powers comes. It is implied. For example, if a state legislature is allowed to make laws on the renting situations or the hospitality situations in the particular state, the center cannot interfere in the matters or in the laws made by the state, and similarly it goes vice versa. Now, concurrent list states certain matters and certain areas where both the state and union can together come about and make and form laws. Okay, coming to the third principle is principle of pith and substance. Now, what exactly pith and substance means? Pith and substance means अगर कोई भी एक particular enactment है और वो substantially किसी और की power में interfere कर रहा है, तो उसमें हमें क्या देखना होता है? What is the main motive of this particular rule is to come to a point and come to a place where you are judging the competence of the enactment. This is how this rule of pith and substance has come into being. You automatically come to check the power of the enactment, the area of its scope, what is it intending to do, how much encroachment is being done, how much interference is being done. It totally depends upon the legislature whether exactly how much encroachment has been done and to what extent this can be prevented, and if not, decisions will be taken accordingly. Now coming to the fourth principle is principle of occupied field. Occupied field basically means कोई भी particular law, मतलब फॉर एग्जाम्पल अगर हम लेते हैं कोई एक स्टेट लॉ है, स्टेट लॉ के पास एक पर्टिकुलर पावर होती है कि इन एरियाज पे आप लॉज बना सकते हो, तो इट इज ऑटोमेटिकली प्रूवन, इट इज ऑटोमेटिकली इम्प्लाइड कि जो यूनियन है और जो सेंटर है वो इन मैटर्स पे रूल्स नहीं बना सकता है, वो इन मैटर्स में इंक्रोच नहीं कर सकता है, वो इन मैटर्स में इंटरफेयर नहीं कर सकता है whatsoever come. There might be chances, there might be cases where encroachment is done. The cases are being held accordingly. We're not supposed to go into details, but you need to understand that this what means occupied field. Occupied means a particular occupation, मतलब एक particular occupied आपके पास particular area है जिस पे आप law बनाओगे, तो वो ही आपका एक particular आपका focus होना चाहिए उस पे. You're not supposed to fiddle with the powers of the center and similarly the center is fiddling with the powers of state. No, that is now how it is done. Now coming to the fifth one is colorable legislation. Now this particular rule is very important from the point of view for your competition exams in the near future, so you really need to read about it on a good strength. Now this particular rule was held and was observed and used under this case KC Gajapati Narayana Deo vs State of Orissa, whereby it was said that what cannot be done directly cannot also be done indirectly. What it means to, what the court tried to say under this particular case was कि कोई भी ऐसा एरिया है, कोई भी ऐसा एक्शन है या कोई भी ऐसा काम है जो हमें लॉ डायरेक्टली अलाउ नहीं करता है, तो वी आर नॉट एंटाइटल्ड, वी आर नॉट अलाउड बाय even by the law to do it indirectly. Any person who is writing the hearing or writing the judgment, or any person whatsoever, no law, no legislature can go against the constitution or do illegal actions to come to a conclusion just for the sake of providing justice. That is not true. We are not allowed. It is not a healthy practice for that matter. So anything, जो भी कोई काम है अगर directly भी नहीं हो रहा है तो आपको वो permission कोर्ट से नहीं है कि आप उसको indirectly try करो. You cannot mold your ways in unconstitutional manner to come to a justice for your own satisfaction. And it has no exceptions to it. There can be no exceptions because it becomes illegal void. There are no exceptions to this particular case. Coming to the sixth rule is territorial nexus. I've been using this word, territorial nexus. I was explaining it to you in the previous lecture also. There should be a territorial nexus, there should be a harmony. What basically territorial nexus means is there should be an alignment. If there are rules, now for example, territorial nexus basically is a terminology used in the international laws, whereby they try and maintain a harmonious territorial nexus between the Indian laws and the laws which are operating on an international basis. Now territorial nexus is also a broad term which is being used under the Indian Constitution under Article 245. Under Article 245, territorial nexus has been defined as a territorial limit of the legislative powers of a court or an enactment. Now for example, territorial of powers of the court. Now powers of the court may extend up to up to a particular district or a particular state. Now what the question right now comes is, now for example, under this particular article it is written, for if the parliament has the power to make laws regarding center. Now all the laws made by the power apply to the whole of the India, right? But now for example, similarly, they should maintain a territorial nexus with the powers, powers which are given to the state. They should be in a manner whereby they can be molded, they can construe. They should not be against these laws of the state. And we are very well aware that all the state legislatures have been given, their own discretionary power to make state laws. Similarly, in the second provision of the Article 245(2), it is written that the state legislature is given powers, discretionary powers to make laws regarding any problem or any particular matter whatsoever it feels, and it should be with a territorial nexus or a territorial harmony with the laws which are made by the center. So this is how you keep a harmony between two things. Neither the laws are contradictory to each other, they are not void of each other. It is not as if state laws cannot, obviously center being the head, center being the apex of everything, will always try to keep changing the laws as they need. Because we have so many states in India, it is very difficult to keep a check and balance, but we are doing a fine job. So, this territorial nexus. Now, territorial nexus also, increases to international level, whereby our international laws, sea laws, and mercantile laws, and all these laws fall under this. The basic purpose of this particular law is to maintain a harmony, is to maintain a nexus, a smooth process, a smooth movement between the two different laws, which might end up working together. Okay, coming to the seventh one is prospective overruling. Now, what prospective overruling? Overruling is a very useful term for us, which means पुराना कोई decision है, उसके बदले में नया decision आ गया तो वो overrule हो गया. Now, prospective overruling means कोई भी पुराना decision है, there is a particular decision which was taken 5 years back, can be overruled in such a manner, can be construed in such a manner so as to provide changes and taken into considerations the present scenario and the present need of the hour. That is the whole motive and the main reason for construing a previous overruling. But it does not mean कि जो ruling अभी आई है उससे previously जो persons affect हुए हैं या previously persons को जो victim हुए हैं या offend हुए हैं उन पे कोई फर्क पड़ेगा. That does not it has not been entertained under this particular rule. New rule which has been new enactment or a new judgment which has been passed overruling the previous judgment will only have prospective effect, will only be started to be followed for the cases which are going to happen in the near future. The whole purpose of coming to a point where you are construing you are overruling a previously held decision is to come to is to change laws, is to change and mold laws according to the needs and the requirements of the people around you. Coming to the eighth principle for today is principle of severability. Severability basically means, for example, you are there is a part, for example, you are having an apple. अब उस apple का आधा part खराब है तो आप उसको काट के साफ वाला part use कर सकते हो. That goes in similar with this principle, whereby it is said whenever an enactment or a statute or a provision of a statute is supposedly or to some extent is unconstitutional, invalid, or ambiguous, it is of no use, a particular part can be severed until and unless it is not making the whole other part unconstitutional, it is not providing justice, it is the other part which is after being severed, the remaining part becomes useless, it is of no use to us, it becomes a dead lumber. Only under taking considerations of those particular exceptions, rules, this particular rule applies where a particular part of an enactment to come to a point where you can sever an enactment, to come to a point to give you a justice or a judgment, it can be severed. Now, when a part of a statute or enactment is invalid, it can be severed. Any part of the constitution, this particular law has been used a lot of times. Now, coming to the last principle we are going to discuss today is the principle of eclipse, again mentioned under the Indian Constitution, Article 13, whereby it means any law which has been imposed or come into force in the India after the commencement of the Indian Constitution shall be invalid. उससे पहले के commencement of Constitution होने के पहले कोई भी laws थे वो invalid हो जाएंगे. कोई भी ऐसे laws जो आपकी Constitution के against जाएंगे या जो invalid हो जाएंगे या inconsistent होंगे वो सब invalid हो जाएंगे. Basically the word eclipse means overshadowed. Previous laws might not be considered as dead. कॉन्स्टिट्यूशन से पहले के जो भी लॉज हैं वो डेड नहीं माने जाएंगे. उन लॉज को ओवरशैडो कर दिया जाएगा. किससे? दे विल ऑल बी ओवरशैडोड बाय फंडामेंटल राइट्स. दे विल बी हैंडल्ड अंडर, ऑल विल बी हैंडल्ड अंडर fundamental rights. So here we finish interpretation of constitution. Tomorrow we are going to start with your last topic, which is last module, module 7. Thank you for
at St. Wilfrid College of Law, Sector 10, Meera Marg, Madhyam Marg, Jaipur, Rajasthan.